Thank you for plugging into this Family Life News podcast, streaming issues-driven, family-focused news.
This is Faith Under Fire. Each Thursday on Family Life, we give voice to religious battlegrounds in this nation. I'm your host, Tracy Lynn. With us today, Kate Anderson, Senior Counsel with Alliance Defending Freedom. Kate, we expect people to be treated with dignity, and that includes fairness in the workplace. But this week's ruling by the Supreme Court now puts sexual orientation and gender identity under the umbrella of civil rights in the U.S. Kate, would you unpack the basics of this ruling and Title VII of the Civil Rights Act?
Well, Title VII of the Civil Rights Act is a non-discrimination law in the employment context, and it has operated since its inception in 1964 to ensure equal opportunities for women, and that was really one of the major concerns going into this case. The question before the court is, what does sex in this federal law mean? Does it mean biology, or does it mean gender identity and sexual orientation? Can the court change it to add those terms? And the way that we analyze these types of laws is to look at their original public meaning. What did people understand the law to mean in 1964? And nobody at that time would have thought the term sex meant what somebody believes they are, their identity, or their orientation. Everyone would have universally thought that sex meant your biology. But the court has now disagreed with that and changed the meaning of that term with some pretty significant consequences. The court actually even went further and said that sex discrimination now means if an employer notices an employee's sex, then they are discriminating against that person. Whereas sex discrimination law, as I said, has always operated to try to provide equal opportunities for women, and they've done that by making sure that men are not treated better than women in the workplace and vice versa. But if noticing sex is the only issue at play, then anywhere that biology actually matters, such as privacy, such as athletic requirements that may be different between men and women for certain jobs, even such as women's shelters, whether men can enter or work for a battered women's shelter. All of those things are now at issue and really can't be cabined in the way that the opinion from the court suggested, and they tried to suggest that these might be left for another day, but certainly activists will try to use this case to really break down the idea of sex being tied to biology in all of these other areas of the law.
Yeah, this creates precedent for future cases. The framers of the U.S. set up the separation of powers. The legislative branch is to create the laws, the executive branch enforces the laws, and the judicial branch was designed to interpret the laws on the books. Justice Samuel Alito, one of the dissenting members on this decision, called the ruling legislation instead of adjudication. How do you see it based on prior law?
Alito is absolutely correct. This was legislating from the bench, and there's a reason why the courts don't do that. Congress is in a unique position to consider the ways that changes to a law like this will impact other people. How does this impact women's sports and their ability to compete for scholarships? How does this impact privacy spaces? How does this impact women's shelter or women's prison? Congress is the one that's supposed to consider all of those things when they change laws. The other reason that courts don't change laws like this is that we want to have consistency in the law. We want Americans to be able to rely on what the law says and not have the law changed out from under them after they've already relied on it, which is what happened here. So both of those principles are very concerning reasons why the court shouldn't have done what it did.
Justice Neil Gorsuch has talked and written extensively in the past about being an originalist and following the law. Do you think people have good reason to feel pretty upset about his part in this ruling?
I think that people have reason to be very concerned that any of the justices on the U.S. Supreme Court would have ruled this way. As we talked about, the separation of powers really leaves to these justices the ability to interpret the law and that role and responsibility, but also the role and responsibility to leave certain things to Congress. So I'm hopeful that in cases to come, there's more of a pushback on that separation of powers.
Kate, in recent years, we have watched people like Colorado cake designer Jack Phillips come under pressure multiple times for standing up for his personal convictions in refusing to create a wedding cake for a gay union. What does the new ruling mean for Christian business owners?
Well, when we see changes like this happen in the law where sexual orientation or gender identity are read into a law that protects against sex discrimination, what we've seen are not cases where true sex discrimination in those contexts or true discrimination of any kind is being stopped. What we're seeing is these laws weaponized to be used against Christians like Jack Phillips, like Barronelle Stutzman, a floral artist in Washington State, like the Ross, to be able to really try to punish them for what they believe. Many people of good faith in this country believe that marriage is between one man and one woman, believe that sex is based on biology, that we are made male and female, and we really should be able to, as a country, support those differences of opinion between people on those issues and respect everyone's beliefs. But that's not really what we see with these kinds of laws.
Absolutely. There are thousands of ministries and churches all over the nation. The big question with this ruling is, what does this mean now for them? Especially for churches and ministries that have a very clear statement of faith when you become an employee.
Indeed, I think it's mixed news for churches and religious organizations around the country. This decision was specific to Title VII, which is the federal employment law that has a religious exemption in that law. What remains to be seen is how strictly that exemption will be applied and how this will work when activists try to take the principles from this case and move them to other laws that don't have those types of protections. So I don't know that the consequence is absolutely immediate on this, but certainly it's reason for churches, religious organizations, people of faith to engage on these issues and to look at their church documents and the ways that they are operating and try to protect themselves as much as possible.
Kate, you are on the front lines of these battles. How can we as listeners also be a part of this fight for religious freedom?
It's always helpful to stay informed and to talk to the people in your community. I think in this country we're having a bit of a crisis of understanding for each other's beliefs and respect for differences of opinion. So people who can talk about their beliefs, the good and value of the family, and of people who believe that marriage is between one man and one woman and that sex is tied to biology, I think it's important for us to be in communication with each other about these important issues.
That's Kate Anderson with Alliance Defending Freedom. I'm Tracy Lynn, Family Life News.